Welcome to a critical examination of international law's intricate relationship with domestic legal systems. This session, set within the high-stakes environment of the Royal Courts of Justice, explores fundamental principles essential for legal training, academic study, and civic education. We delve into on the application of Global Rights Watch v. Secretary of State for Justice, a case scrutinizing the UK government's adherence to international human rights obligations. The proceedings commence with Ms. Patel, Counsel for Global Rights Watch, asserting the UK's commitment to international treaties. These formal agreements between states are legally binding under international law. She highlights the International Covenant on Civil and Political Rights, ICCPR, as a cornerstone, ratified by the UK, which protects fundamental protest rights. Ms. Patel further emphasizes the European Convention on Human Rights, ECHR, a specific type of treaty known as a convention. The ECHR establishes broad human rights standards across Europe, binding its signatory states. Its provisions are central to the current legal challenge. Mr. Hughes, representing the government, clarifies that while the UK is bound by the ECHR, its obligations are defined by ratified protocols. Protocols are additional legal instruments that amend or supplement the main convention. The UK's selective ratification means certain provisions, like Protocol 12 on general non-discrimination, may not apply domestically. The court then considers customary international law, derived from consistent state practice and a sense of legal obligation. Ms. Patel cites Trentex Trading Corp v. Central Bank of Nigeria, affirming that customary international law can integrate into English common law unless statutory conflict exists. This demonstrates a dynamic interplay between international and domestic legal sources. The judge probes the mechanism of incorporation, how international obligations become domestic law. Ms. Patel points to the Human Rights Act 1998, which incorporates the ECHR into UK law. This act makes ECHR rights directly enforceable within English courts, a crucial step for human rights advocates. Mr. Hughes articulates the UK's dualist legal theory, asserting that international and domestic law are distinct systems. Treaties do not automatically gain domestic effect without parliamentary incorporation. He references Smith v. Smith and another, 2006, UKHL 35, confirming that unincorporated treaties lack direct enforceability in UK courts. Ms. Patel counters by contrasting dualism with monism, where ratified treaties automatically integrate into domestic law. She cites the Dutch system as an example, where international law can override national law without further legislation. This theoretical distinction profoundly impacts legal application. The ECHR stands as the cornerstone of this case, as noted by the judge. He references Alskaney and others v. United Kingdom, where the European Court of Human Rights affirmed the UK's ECHR obligations can extend to actions abroad. This broadens the scope of accountability. Finally, the judge focuses on the Human Rights Act 1998. This act mandates that all UK public authorities act compatibly with the ECHR. It empowers individuals to bring claims in UK courts, as exemplified by A and others v. Secretary of State for the Home Department, 2005, UKHL 71, which struck down indefinite detention as incompatible with the ECHR. This scenario underscores the complex interplay between international commitments and national sovereignty. Understanding these principles is vital for legal professionals, human rights advocates, and informed citizens. We urge you to delve deeper into these concepts, analyze their implications, and engage in the ongoing debate about the role of international law in protecting fundamental rights. Your critical engagement is essential for upholding justice and accountability.